Picture this for a moment. Eleanor is 73 years old. She is sitting in her living room recliner on a quiet Thursday afternoon. The mail just came. Her tea is still warm on the side table, and in her lap is an envelope from a tax attorney that she does not want to open. 3 years ago, after her husband Frank passed away, her daughter sat next to her on that very same couch and said, "Mom, let me help you with the house. Just add my name to the deed. It will make everything so much simpler later on." So Eleanor did it. She drove down to the county recorder's office. She paid a small fee. She signed her name. The clerk handed her a copy and said, "Have a nice day, ma'am." That was it. She thought she had just done the most loving, responsible thing a mother could do. She thought she had protected her daughter from probate, from lawyers, from a long and painful court process. But the letter in her lap right now says something very different. It says that one signature on one piece of paper at one county office may have just cost her daughter more than $90,000 in federal capital gains tax. $90,000 on a house that Eleanor and Frank had already paid off years ago. And the worst part, she cannot take it back. Hello, my friend. I am Milena, Senior Policy Analyst here at Silver Law and Money, and I need you to stop whatever you are doing right now and listen very, very carefully to the next 10 minutes. Because if your name is on a house and you have also placed your child's name on that same deed, you are sitting on what the IRS quietly calls a carryover basis trap. And in 2026, with home values where they are today, this trap is more expensive than it has ever been in American history. Today, I am going to walk you through 3 things. First, I will show you the exact IRS rule, in plain English, with no confusing legal language. Second, I will tell you the story of a retiree named Robert, and what one simple mistake cost his family. And third, I will give you the 3 specific steps you must take this week to protect your home and your children's inheritance. And please, stay with me until the very end of this video, because there is one hidden mistake that thousands of seniors make every single year, and it is the mistake that turns a $40 trip to the courthouse into a 6-figure tax bill. I do not want that to be you. I do not want that to be your family. So, let me tell you about Robert. Robert is 68 years old. He worked 34 years as a postal supervisor in Ohio. His wife Linda retired from teaching elementary school. Together they raised 2 children in a 3-bedroom colonial they bought back in 1982 for $52,000. Today, that same house is worth $480,000. Robert is a careful man. He reads, he plans. He watches videos just like this one. And one afternoon, his neighbor leans over the fence and says, "Robert, you should add your daughter Jennifer to the deed. That way, when something happens, she just gets the house. No probate, no court, no headaches." Robert thinks about it for 2 weeks. It sounds smart. It sounds responsible. So he drives to the county courthouse, pays the recording fee, and adds Jennifer to the deed as a joint owner. He comes home and tells Linda, "Honey, I just saved our family thousands of dollars in legal fees." 6 years later, Robert passes away. Linda, heartbroken and now in her 70s, decides the house is too much to handle alone. So she and Jennifer agree to sell it. They sell for $480,000. Clean sale, no problems. Then tax season arrives. Jennifer's accountant calls her on a Tuesday morning and says, "Jennifer, you owe the IRS about $68,000 in federal capital gains tax, plus state tax, plus the net investment income tax." Jennifer almost drops the phone. She says, "But it was my father's house. I inherited it." And the accountant says the words that every single senior watching this video needs to hear right now. "No, Jennifer, you did not inherit it. Your father gave it to you back in 2020. The day he added your name to the deed. And under IRS rule, section 1015, that means you took his original purchase price. You took the $52,000 he paid in 1982, not the $480,000 it was worth on the day he died. That, my friends, is the trap. So let me explain exactly what happened in the simplest words I can use. The IRS has 2 completely different rules for how a home gets passed down, and which rule applies depends on one single thing: whether you transfer the home while you are still alive or whether your children receive it after you pass away. The first rule is called stepped-up basis. It comes from section 1014 of the tax code, and here is how it works. When a child inherits a house after a parent dies, the IRS resets the value of that house to whatever it is worth on the date of death. So if Robert had simply left the house to Jennifer in his will, the basis would have been stepped up to $480,000. Jennifer sells it for $480,000. Her taxable gain would have been $0, zero tax. That is the gift Congress gave to American families decades ago. The second rule is called carryover basis. It comes from Section 1015 of the tax code. And this is the rule that quietly destroys the finances of seniors who add their kids to the deed while they are still alive. Under carryover basis, when a parent gives property to a child during their lifetime, the child does not get a fresh start. The child inherits the parent's original purchase price. Whatever you pay for that home in 1975, in 1982, or in 1990, that is the number your child is stuck with forever. The IRS confirms this in Publication 551, the Official Basis of Assets Guide, December 2025 edition. It says, and I am quoting directly, "To figure the basis of property you receive as a gift, you must know its adjusted basis to the donor just before it was given to you." And here is where it becomes even more dangerous. When you add your child's name to your deed, the IRS does not view that as a small paperwork change. The IRS views it as a completed gift of half the value of your home. Right then, right there, on the day you sign that piece of paper. If your home is worth $400,000 and you add one child to the deed, you have just made a $200,000 gift in the eyes of the IRS. And that triggers another serious problem. And in 2026, the annual gift tax exclusion is $19,000 per recipient. Any gift over that amount requires you to file IRS Form 709, the United States gift tax return. Even if you do not owe a single penny in tax, you still have to file that form. Most seniors never file it. Most seniors do not even know it exists. And the penalty for failing to file Form 709 is 5% of any unpaid tax per month, up to 25% plus interest. And here's the part that really hurts. The statute of limitations never starts running until you file, which means the IRS can come back and audit that gift 20 years later, 30 years later, after you are gone. Now, I know this is heavy, so take a slow breath with me. Because I want to share something even more important, something AARP itself has been warning seniors about for years. In an article published on AARP.org, financial advisor Patricia Hausknost said this, and I want to read it to you word for word. She said, quote, "Some parents are tempted to transfer title of the house to their children while the parents are still alive. Don't do it. The heirs will be responsible for the house expenses, including liability, and they won't get the step up in basis." That is not me saying that. That is not some blog. That is AARP, the largest senior advocacy organization in America, telling you in plain English, do not do this. But here is what most articles will not tell you. The capital gains tax is only the first consequence. There are 4 more, and each one is just as dangerous as the first. The second consequence is the loss of your Section 121 home sale exclusion. This is the rule that lets a married couple exclude up to $500,000 of gain when they sell their main home. But the moment you add a child to the deed, that exclusion only protects your portion of the sale. Your child's portion is fully taxable unless they have actually lived in the home as their primary residence for 2 of the previous 5 years. The third consequence is Medicaid disqualification. Under federal law, found at 42 U.S.C., Section 1396P, there is a 5-year look-back period. If you apply for Medicaid long-term care within 5 years of adding your child to the deed, the government treats it as an uncompensated transfer. They calculate a penalty period during which Medicaid will pay absolutely nothing. Nothing for the nursing home. Nothing for memory care. Nothing. The fourth consequence is the one that almost nobody talks about. The moment your child's name appears on your deed, your home becomes legally exposed to your child's problems. If your son goes through a divorce, half of his interest in your home can be claimed by his ex-spouse. If your daughter is sued by someone, the plaintiff can place a lien on your home. If your child files for bankruptcy, their share of your home becomes part of the bankruptcy estate. You did not create any of those risks. Your child did. But your home is what pays the price. And the fifth consequence, the one I want you to remember most of all, is that once it is done, you usually cannot undo it. The moment that new deed is recorded at the county office, your child is a legal co-owner. To remove them, they have to sign a new deed, voluntarily. And if they refuse, or if a creditor has already attached to their share, you may be locked into a situation you cannot escape, no matter how much you regret it. Now, I know exactly what some of you are thinking right now. And, Milena, this is frightening. What do I do? My name is already on a deed with my son, or I was about to do this next week. Where do I start? I am going to give you 3 exact steps. Please write them down. Pause the video if you need to. Step 1. Before you change anything on any deed, contact a qualified estate planning attorney in your state. Not a general lawyer, not your cousin who does real estate closings, an estate planning attorney. A 1-hour consultation usually costs between $200 and $500. That single consultation can save your family $100,000 or more. AARP has a free legal services directory at aarp.org/money, where you can find resources in your local area. Step 2. If your real goal was simply to avoid probate, ask your attorney about 3 specific legal tools that protect your home while still preserving the stepped-up basis. The first is a transfer on death deed, also called a beneficiary deed, which is available in most states. The second is a revocable living trust. The third, if you live in a state that recognizes it, is a life estate deed with retained powers, sometimes called a ladybird deed. All 3 of these accomplish exactly what adding your child to the deed was supposed to do, but without destroying the step-up in basis under IRS Section 1014. Step 3. If you have already added a child to your deed, please do not panic, but please do not delay either. Schedule a meeting with both an estate attorney and a CPA at the same time. There may be options available to you. You might be able to remove the child from the deed if they are willing to sign. You may need to file a corrective Form 709 with the IRS. And in some cases, depending on how the deed was originally written, you may still qualify for a partial step-up if you retain certain ownership rights. But every month you wait is another month the situation gets harder to fix. And now, my friend, here is the hidden mistake I promised to share with you at the very beginning of this video. The biggest mistake seniors make is this. They assume that because adding a child to the deed is perfectly legal, it must also be safe. They assume that because the county clerk did not warn them, there must not be a problem. They assume that because a neighbor did it or a friend did it, it must be fine. But the county recorder is not a tax advisor. Your neighbor is not the IRS. And legal does not mean smart. The IRS will not call you to warn you. The IRS will not send a friendly letter saying, "Hey, you might want to reconsider this." They will simply wait. They will wait until you or your spouse passes away, until that home gets sold, and then they will quietly send a tax bill to your child for $60,000, $80,000, or even over $100,000. And by then, it is far too late to do anything about it. So please, please hear me on this point. Do not rely on YouTube notifications to keep you informed about changes in tax law. Do not rely on advice from a friend at church. Do not rely on a single article you read online late at night. Go to irs.gov and read Publication 551 and Publication 523 yourself. Go to aarp.org and read what they say about estate planning. And most importantly, please talk to a licensed estate planning attorney in your state before you sign anything that changes the ownership of your home. Your home is likely the largest asset you will ever own in your life. It is the foundation of your family's future. Please, please do not give it away with a $40 trip to the county courthouse. If this video helped you today, do me one small favor. Share it with one other senior you know, one friend, one sibling, one neighbor down the street. Because somewhere out there right now, there is an Eleanor or a Robert about to make this exact same mistake, and you might be the one person who saves them from it. I am Milena with Silver Law and Money. Thank you for trusting me with your time today. Stay informed, stay protected, and I will see you again in the next video.